This could be a miscarriage of justice on a scale that this country has never before seen, with around 75,000 people wrongfully prosecuted for railway offences. So what is this all about? You've probably seen it in the media, and for a fresh alternative to the mainstream media, do consider subscribing to my channel for a raw and brutal analysis of how the law applies. You can even join as a member, and don't forget to ring that notification bell so you don't miss out on future videos. So of course, I'm talking about this test case here, where half a dozen people came to court for a test case as to whether or not they were properly prosecuted under the law. Spoiler alert, the reason I'm doing the video is that it was not lawful, which has given rise to probably the most catastrophic failure of justice we've seen for a long time, in terms of numbers at least. Now, this came before the Chief Magistrate, Senior District Judge Goldspring, for offences that were prosecuted for railway offences under either the Regulation of Railways Act 1889 or bylaw offences, and this is what the discussion was all about. You see, railways have been prosecuting people for offences under the Regulation of Railways Act of 1889, and Transport for London typically prosecutes people under the bylaws for Transport for London, and there's a very important distinction between the two. You see, under the Regulation of Railways Act offence, under Section 5, the penalty for avoiding a payment of a fare includes this very important word here, intent. If someone travels or attempts to travel on the railway without having previously paid the fare and with the intent to avoid payment thereof, they can be prosecuted under Section 5 of this Act. The regulations, the bylaws, for the Transport for London prosecutions are a strict liability offence, meaning it doesn't matter whether you intend to or not. If you travel and you don't have a ticket, you're liable for that offence. However, here comes the very difficult part here, in that these companies have been prosecuting people under Section 5 of the Regulation of Railways Act 1889 under the single justice procedure. Now, that might sound familiar to you in that I've mentioned it before to do with TV licensing, because if you ignore the intention to prosecute you, i.e. you don't respond to refute the procedure or you don't respond to submit a not guilty plea, you can then be prosecuted under the single justice procedure, meaning it's all behind closed doors, there's no court hearing, there's no representation, they just hear it in your absence, and by and large, you can probably guess for the vast majority of them, they find you guilty. Now, there's a specific set of laws that set out framework that sets out the laws for the single justice procedure. It's under Section 16A of the Magistrates Court Act 1980. So, on a written charge in accordance with these sections, someone that is accused of this offence which is not imprisonable and is 18 or over, and the court satisfied the documents have been served, and that the accused has not responded to refute the single justice procedure, not responded with a not guilty plea. In other words, if they haven't responded to refute the use of the procedure, they haven't responded with a not guilty plea, they can, in certain circumstances, be tried on a single justice procedure, meaning it's just on the papers behind closed doors, no court hearing, etc. However, here's where the problem comes in. The railway companies have been prosecuting people using the single justice procedure when they didn't respond to their notice of prosecution under Section 5 of the Regulation of Railways Act 1889. But the big problem there is they weren't allowed to, because there was an order in 2016, which was the Criminal Justice Act 2003, New Method of Instituting Proceedings, Specification of Relevant Procedures Order 2016, to institute proceedings by a single justice procedure. In other words, it allowed by single justice procedure to proceed for railway offences. But the problem was, it wasn't envisaged to incorporate those offences under the Regulation of Railways Act 1889. Long story short, the judge said the ultimate question for the court is whether, when properly examined, there was non-compliance with what Parliament intended when bringing these prosecutions by the single justice procedure. And the judge said the answer, to my mind, is clearly yes. Parliament did not envisage these offences being prosecuted through the single justice procedure. They should never have been brought through the single justice procedure in the first place. That is, to my mind, a paradigm nullity. And so, concluding at the very end, for all these reasons, I am satisfied the correct approach is to declare each of the above cases void ab initio and a nullity, and I do so. In other words, void from the beginning, they should never have happened, and as of this moment, they are nullified. So that means a whole number of things. First of all, how many tens of thousands of people have actually been prosecuted, fined, and had to pay these fines of up to £500 apiece? And all of those are now to be contacted, I understand, with the goal date by the end of September to bring them all together as a case by the end of October, which to my mind sounds quite optimistic. But the rail companies say they are going to contact all of these people and say, yep, sorry about that, we shouldn't have prosecuted you. We're going to bring this back to court because presumably they're going to get their money back because they should never have been prosecuted if they've paid a fine. But that then also raises another question. What about however many thousand people were actually guilty of this offence, who now probably won't be tried because it'll be past the statutory time limit for summary-only offences? But what about all of the costs incurred by both the case that's just been heard, the case that will come to court, and everybody else's costs and time and energy and everything else in corresponding with these companies for wrongly prosecuting them in the first place? But as I always say, this is a warning not to ignore any intention to prosecute you, because if there's an offence that can proceed by way of single justice procedure, they'll proceed in your absence and they'll probably find you guilty, because if they've got evidence to prosecute you, they'll probably find you guilty if you don't refute it and you don't defend it. So it's always better to respond to these things, either to say you refute the procedure or you plead not guilty, ideally not guilty if you are not guilty, and if you are guilty and you know you're guilty, then plead guilty because you'll likely get a lesser sentence or lesser fine. So if you found that useful, please do consider subscribing. Subscribe also to Art of Law Al's channel because you'll probably get more scenic views because he gets out and about more than I do, and you'll probably learn some history along the way too. So I hope you enjoyed that. Thank you for watching, and I'll see you next time.